All right, New York Stock Exchange and over-the-counter transactions, National Social Security deposit, um, deposit, NSDA, Chapter 6, opening and handling of accounts. When prospective companies customers seek to open a new securities account with a New York Stock Exchange member, the firm of the registered representative, RR, is required with the due diligence a certain relevant personal financial information about the person needed and the ability is usually called the Know Your Customer Rule, Rule 405. This requirement can be summed up in one word: suitability. No registered representative should solicit or accept, and no member firm should permit any transaction which, based on customer information, is not suitable. Based information required with the general agreement with among brokers as to the minimum information necessary to satisfy the New York Stock Exchange Rule 405. There may be considered variance between the firms, and the amount of the information must be on the new account from the prior to its approval by office manager. Large firms tend to enforce fairly rigid practices. Smaller firms tend to be more flexible, especially in small communities. As an amount of the type of the information necessary for the new accounts reports to the left of the compliance department of each firm, which appears to be an easy rule for live with. Quite contrary is true of the required to know your customer, despite the great and taking care something goes amiss with the account. You and your firm will be considered in violation of the very general rule. An industry would prefer specific requirements, no matter how demanding some area of the industry. Such option municipals do have participating information standards, such as the NASDAQ and the National Associations, NSAD. More general, leaving final judgments of the firm, their representative, full name and address for the post office box, the mailing address, actual home, business address must appear on the form. A post office box alone is not acceptable. Social Security and taxpayer identification under federal law. Brokers must report dividends to the customer accounts as well as the other relevant information. Age: customer must be a legal age to transact business, enter for the business bill, that binding contracts, employment status such as employer, self-employed, retired, required. New York Stock Exchange rules require special permission for certain type of accounts and employers. See below. Marital status: sponsor's name if married, and if required, dependents number. The dependents you declare on your income tax. Investment objective such as speculation. Length of the growth of the capital and the income is required that the necessary to match security recommendations to the suitability requirements of the customer. Net worth is required for the option account. Net worth is everything with other than the principal residence. For the liquid net worth, annual income and investment experience. For the net worth is useful with no but under any circumstances, but specified by the options of the exchange due to the additional risk inherent in many options transaction. Other information without the NASD required customer name and address of the correspondent to be sent with a P.O. box. The actual address of the customer must be on file with the customer. Of the legal aid, signature of the registered representative opening the account, signature of the principal approving the opening of the account. Additional information should be obtained: taxpayer identification number, citizens of the citizenship of the customer, occupation of the customer, special employment consideration because of the potential conflicts of the interest accounts of the employee of the members of the organization of the New York Stock Exchange required additional care. Any account of the employee of the New York Stock Exchange and subsidiaries include officers that require a prior written consent for the exchange of the accounts of the employees other than the New York Stock Exchange member firms require prior written consent of the employer and duplicate confirmation of account statements forward to the employer documentation. There is no standard policy on cash accounts. Most firms request sample of the customer signature card, but cash amount can be opened and traded with no documentation other than a new account form of any kind. On margin account, the customer may sign a hypothecation margin or customer agreement to collateralize any loan he may use. Most firms also ask the customer to sign a stock loan consent, allowing the broker to loan the customer margin securities to the others. The document is often included in on the same sheet with a hypothecation agreement. Federal law requires the broker to provide marginal customer with the truth in lending. The statement describing the loan in terms and rates. The document need not to be signed by the customer. Additional document is required for the most accounts below discussed in each section. Third-party accounts: normally orders may be accepted only from the principal owner of the account, with occasionally the customer may delegate with the trading decisions to another person with the often investment advised by assigning power of the attorney in favor of that party. This allows the holder of the power of the attorney to enter with the direct orders directly to the registered representative without prior consultation with the customer. The most common type is limited power of attorney using called the trading authorization when limited to the security transaction. Become more comprehensive full power of attorney, which also allows funds and security to be withdrawn from the account by the holder, being seen more often these days. To accept an order on an authorized party is a serious violation. Yeah.
Well, Kara's on the phone. They want to talk to you.
Alright, third-party accounts. Normally, orders may be accepted only from the principal owner of the account, with occasional cuffing by the delegated trade issues to another person or the investment advisor by signing with the power of attorney in the favor of the party to allow the holder of the power of attorney to enter the orders directly with a registered representative without prior consultation with the customer. Most common type of limited power of attorney, usually called the trading authorization, limited to security transactions. More comprehensive full power of attorney, which allows funds and or security to be withdrawn from the account by the holder if it has been seen more often these days. To accept an order on an authorized party is here the violation of the New York Stock Exchange rule and the cause for the registered representative liable for any loss suffered. Sometimes a problem arising involved with a married couple is not uncommon for a customer phone to the registered representative, say with a 5 to 200 GM, and put 100 in my wife's husband's account. Unless the spouse has the power of the attorney, order is illegal and should be refused unless the registered representative first confirms the order with the other spouse. While this may be the embarrassing, the registered representative is better than having the spouse disavow the trade, leaving the registered representative without any loss. Discretionary accounts. Trading authorization is made on and out in favor of an employee with a member of the firm, generally with it as registered or representative account is considered discretionary because of the inherent potential conflict of interest. Many of the members do not allow such accounts, while there are specialized discretionary accounts for those that do allow. The New York Stock Exchange rules require one prior written and request discretion from the customer, 2 accept the account in writing by a member or allied member of the exchange, 3 making each order discretion, getting approval in the writing by initial of each of the ordered by a member, allied member, or branch office manager. 4, frequent supervised review to protect against churning and unsuitable recommendations. Time and practice execution may be orally delegated by the customer without regard to the rule. Hence, an order to buy 500 KQB sometimes today in the market weekends. It's acceptable even without a signed power of attorney because of the potential understanding that most firms do not permit such orders as matter of house policy. Number of coded accounts. Protect confidential with the customer account. The New York Stock Exchange rules permit the carrying accounts the under code name numbers and aliases. Customer must provide written acknowledgement of the ownership account and provide all new information for the broker's records of the customer. Confirmed statements will be printed on the code title. Custodial accounts. While minors may own securities and receive their variety of ways, the ability to enter the binding contracts to acquire the dispose of such property is strictly limited. For this reason, the most security transactions involving minors brokerage firms are affected through the custodial accounts under the Uniform Gifts to the Minors Act. A number of the states have been passed a very similar version of the Uniform Transfer to the Minorities Act, or UTMA. In this account, the adults act on the minor's behalf until the age of the majority is reached. Account title: 1 custodian per 1 minor per account. With this view, the just custodian, just recipient is not permitted. The typical account title would be Jane Doe, custodian of Thomas Doe, UGMA. State of Minnesota, legal residence of the minor. Type of the account: amount of cash only, no margin. Type of the gifts: security, cash, insurance policies are permitted. All gifts are irrevocable, become the personal and property of the minor, where bearer certificates are donated to the donor and custodian may not be the same person. All those type of the certificate must be accompanied with a revocable deed of the gift. Permissible infant investment activities. All states permit with reasonably prudent investments on behalf of the minor. Prohibition, marginal transaction rules of short sales, commodities, and many types of option trading with the custodian. 1, buy and sell with the custodian property deemed best. 2, subscribe to the rights, offering liquidated rights. Deposit additional cash to the round up to new shares in such an offering. 3, liquidate all and part of the custodial property to finance major benefits for the minor, college tuition, etc. Prohibited activities: the custodian may not 1, pledge or lend custodial property. 2, with commingle personal and custodial funds. 3, use custodial property to answer marginal calls or make temporary loans to personal accounts. 4, use custodial property for financing normal out-of-pocket costs associated with raising children. Fees: ordinarily a custodian may charge with reasonable for a fee for a service. The custodian is also the donor of the property. However, fees are not permitted. A few states limited the payment of fees to the bank or trust company. Such limitations are unusual. Tax consequences. All tax liabilities, such as the custodial property belonging to the minor. For this reason, the minor's social security number must be on the account, generally preferred for the parent, not as a custodian. For offspring with substantial gifts are involved by a custodian, property donated by the parent will be included in the parent's estate should he or she die before the minor reaches maturity. Death of the minor custodian. If the minor dies prior to the reaching majority and any custodial property becomes of the minor's estate, then will be probated. If the custodian does prior to the minor's majority, legal guardian normally becomes the new custodian, reaching majority. Upon attaining majority of the state legal residence, the minor assumes legal responsibility for the contract's custodial relationship. If it exceeds, the former minor may present the security certificates to the transfer agent, who will then register the ownership in the new name. Although the custodian authority ceases on the minority's majority birth date, new date may then legally delegate a power of attorney to the person. Joint tenancy accounts. These accounts are property of the jointly owned by two or more parties. The two most common are the joint tenancy with the right of survivorship, or WROS, and tenancy in common, TIC. In either case, all tenants are equally empowered to transact business in the account. In order to transfer property, all tenants must endorse a certificate. Upon death of any tenant, the tenancy is dissolved. In this case, with the rights of survivorship accounts, the surviving tenant is sole owner of the account. In this case, the tenancy in common accounts, or the deceased tenant portion, becomes part of that of the tenant's estate. Serving tenants may either distribute the remaining established in the new tenancy. Corporate accounts. When accounting is opened in a new corporation, corporate must furnish one corporation resolution document to sign with the directors empowering certain persons on behalf of the corporation, for example, enter order significant signed certificates. 2. The corporate charter and exam expert from the chart that authorizes security transaction. All of the use of the new account information must be recorded. Data customer. Death of customer. Upon learning of the customer the death of the registered representative, first step is to cancel all open orders. But then the next step is to change the amount on the title. For example, the John Joe is deceased, to enter the block of the account with the further trades pending and receive the appropriate documents. These include copy of the death certificate, copy of the will, copy of the court's appointment of the executor for the administrator, which establishes even the executor administrative rights for the act for the estate letters testamentary. Estate tax waivers will establish that there are no further estate tax claims against the property requirements for the area that has been ceased for recent years. Affidavit of domicile establishes the state of legal residence, time of the death, who laws apply with the settlement of the estate. Exchange regulations. In the New York Stock Exchange, registered representatives are expected to devote full time to the job, and the outside employment required with prior written consent of the employer. Firms are not allowed to hire registered representatives in a nominal capacity solely because of the business obtained by such a person. For instance, a firm could not appoint a practicing physician as a registered representative merely as a funnel for other orders directed by colleagues. Other important regulations covering the activity of the registered representative include keeping a book. A registered representative is expected to keep a record of all customer transactions listed by the date, including the number, share, the name of the security, and the price. Transaction should be posted on the day of the registered representative received the confirmation of the trade. The book is the property of the firm and should be the registered representative and leave the records remain with the firm. Speaking and writing activities and development of the clientele, a retail registered representative will also certainly be involved in the endeavors in order to become the widely known prospective customers. Care must be taken and ensure the New York Stock Exchange rules on stability of the recommendations strictly observed. And speaking in ease, engagement, and arrange with the registered representative invited to speak for both the general audience of Mason VFW, Elks, etc. The talk must be in general nature. No specific security recommendations may be made. Any literature to be distributed must be on a pick-up-only basis. All speaking engagements must be recorded on the firm's log. In the prospective climates of the involved with the broker firms to attend the investment discussion seminar, specific recommendations may be made. Literature may be distributed to each participant. Thus, in the firm advertiser for the seminar with investing high-risk special situation, investor who accepts the invitation to attend may be handed copies of the research reports or other literature, as well as receive verbal recommendations. Teaching activities. Registered representative may teach courses of the recognized educational establishment, university, common college, adult education center, etc. Prior permission of the employer is required. That the registered representative must also file a copy of the course outline synopsis of the firm's log. Teaching must not interfere with the regular business day of the registered representative. Any of the compensation must be the normal rated pay with the regular academic duties of a similar nature. Correspondence. All income correspondence, including personal mail received at the branch office, must be opened by the officer manager authorized delegate. Should the registered representative receive the business-related correspondence at home, it should be immediately turned over to the manager. Outgoing correspondence must also be reviewed and approved by the office manager of the delegate. The exemption of the rule, brief note of the office accompanying with a research report or sales literature, which is not specifically recommended the security of the course of action. Here's our report in the microchip industry as promised. Regards, Jim. If the registered representative wishes to write a letter illustrating the success of the investment selections, all the other recommendations made in 12 months must be shown, including the date and price when recommended with the purchase and or sale, current value of the position is still extant, and at all costs, the letter must also contain a statement of the effect of the past performance may not be indicative of the future results. Any test transmitted letters even to indicate the fee of the gratitudes were paid to the person providing the testimony. Advertising. All large firms, many smaller ones, individual registered representatives not allowed to advertise independently, which are allowed, however, all copies must be submitted to the firm's authorized party. Advertising directors, compliance officers for prior approval. If the opening options are involved, the firm's compliance registered option principal must be given the prior approval. The copy must be submitted to options exchange at least 10 days prior to the first use. A firm with an NASD only member regulating advertising must be submitted to the NASD no later than 5 days after the first use. 3 days when the topic investment company shares. Outside the directorship, the registered representative may, while the employer's prior approval, to hold up to 3 directorships in non-financial corporations, 1 directorship in a bank, any directorship in a financial organization, and or any directorship except in limits above that requires prior approval of the New York Stock Exchange. Orders and tickets. When entering the order, registered representative is responsible for seeing all required information, including the order and at the time of the entry. Necessary information includes the name and the number of the account number to share with the market, New York Stock Exchange, American, ASE, OTC, etc. Buy or sell long or short, security description, name or symbol, type of the order, market, limited stop, time, qualification, day, good, unit, canceled. Day or good unit canceled. Any other necessary information such as payment, delivery instructions must also be included. Many firms no longer use hard copy order ticket. They buy and accomplish via the computer. However, the information is required both the ticket and the screen. Exchange markets. Alright, exchange markets. Trading and stock exchange. Stock Exchange of the United States became in the later part of the 18th century the professional New York Stock Exchange, the nation's largest exchange, founded in May 1792. It began an outdoor market, was founded by a group of men who were the primarily commodity brokers and meet each day with the trade of the few securities available at all time in the return of the major business community. Commodities Exchange was founded under the Buttonwood Tree Agreement as an original location under which a tree on the Wall Street, although no longer exists, commemorates as the location of this historic event. Valuation trading of the exchange has resulted in which is known as the auction market. In this form of trading of the continuous bidding and offering during trading day to 9:30 a.m. to 4 p.m. Eastern, and completion between both buyers and sellers result of the transaction most equitable price at any given moment. Although the New York Stock Exchange is the far the largest, there are 6 other exchanges required security registered with the Security Exchange Commission: the American Stock Exchange in New York, Boston Stock Exchange, Philadelphia Stock Exchange, the Chicago Exchange, Cincinnati Exchange, and Pacific Exchange, Los Angeles, San Francisco. Trading on each of the exchanges is quite seldom. Member of the firm or the exchange member that receives an order of 100 shares of General Motors at the market. Market orders will be executed at the best price available at the time. The orders are transmitted to the floor of the exchange, given to a member to the exchange, usually called a broker. The member may be employed by the firm entering the order, but may be an independent broker who executes orders for the others, receiving a fee of floor brokerage for those efforts. The independent brokers are called $2 brokers, as the fee originally is charged to each 100 shares. Since these fees have been negotiated by parties, but the name of the $2 remains. The broker holding the order will proceed with a particular location of the floor known as the trading post. Each security is assigned only one post of all the orders by and sell of the security will coverage at the one location. As a post broker will find another exchange member known as a specialist whose function is to provide an orderly market and securities assigned to him. He will provide our broker with a current quotation on the General Motors, say perhaps GM at 47 to 47.50. The quotation tells our broker the highest price anyone is willing to pay. The bid is for $47. The per share lowest price which anyone will sell the offer is axe priced at $47.50 for the per share. The specialist will tell our broker the size of the market, saying 700 by 900, which means there are $47 share per share will be paid for 700 shares, and that 900 shares are offered at $47.50 per share. Our broker could buy 100 shares immediately at 47.5. He could make a bid higher than the best current bid at 47 and hope some other firm might accept his bid and sell him the 100 shares of stock. The bidding and offering and completion with the other provides with a continuous auction market. Some orders contain specific permanent price limitation. For example, sell 100 IBM at 99. This indicates that the stock can be sold at $99 per share or higher, but any price lower than 99 per share. Any price lower than $99 a share. Often the limited order the replace of the price if not feasible at the time in which they are entered. Perhaps IBM is trading at $95 per share when the order to sell of the 99 reaches the floor. In this case, the firm may give the order to a specialist to handle for them. He will note this order on his book, and should the IBM rise to the price of 99, he will sell the stock for us. He will of course charge us a fee, but by giving him an order for the freeze, our broker handled the other more independent businesses. By employing auction process, exchange, trading, insurance, the best available price at any of the given moment, the prior change continually with the changing all orders, particular security, one location. All buyers and sellers complete with equality. Electronic trading has increased dramatically. However, the concept described above is the same. Consequently, the speed and volume of the trades has increased dramatically as well. In the addition, increase of the electronic trading will allow the future growth. Type of security orders. Market. The market order, MKT, requires immediate execution of best available price and order of the buy 100 shares of Ford Motor of the market. Instruct the broker handling the order to purchase the share of the best current offering should the stock be quoted at 8 to 8.3. Best current with the offering is 8 and 28 and a quarter for the broker will purchase the shares at that price. So should he attempt to buy at a lower price, he runs the missing the market should the forced buy and he will be forced to later buy the shares above 8.25. He would be responsible to the customer for the difference in the price. Limited orders. The limit order to buy a specific maximum price of the buyer is willing to pay. Limited orders to sell specifically minimum price the seller is willing to accept. Limited order contains specific price, thus an order of 300 ABC at 30 instructs the broker to buy 300 shares of ABC at any price up to and including but never more than 30. Stop. The stop order to buy or sell is used to make transactions only after a certain price of the reach of the stop price is touched past and the order is said to be elected, triggered, or activated. The order that becomes a market order and will be executed at once as soon as possible. Sell stop orders are used 1 to liquidate long positions, either the protocol protect profits if the stop loss is hence the obsolete and inaccurate. Most common reference is stop loss orders. 2 initiate short position by stop orders, usually mainly to 1 cover short positions, or 2 stops long positions on charting breakout. Stopping limit. Stopping limit order, especially with the same as the stop order, except that it becomes a limited order, not a market order. Upon being elected triggered, the order may be specified at the same stop limited prices and split them. For example, to sell 100V at 29 stop limit or 29 STP limit would require the sale at 29 or below to elect the order. Minimum price of 29 would be necessary to execute. On the other hand, in order to buy 200X at 45 stop limit order 46 would be elected by the sale of 45 or higher and order filled at any price not higher than 46. No, on the American Exchange, round lot stop orders are not permitted, and an order entered with a stop must also contain a limited sale price. Limit at the same price. Sell 200 MTT at 33 stop limit. Other exchanges do not require this procedure. Example execution security orders. Market order by 100 LMN at MKT. After the receipt of the order, the LMN trades over the orders occur at 85 and a quarter, 85 and a half. Orders executed at 85. As with the first one to occur after any entry of the market order. Limited orders sell. Sell 100 TIRA at 32 after entry of the order. TIRA orders that occurs at 31 and a quarter, 31.85, 32 and a 12. The order is executed at 32 and a 12. The client would sell at 32 or better. Limited order bar. Buy 100 DOD at 12 after entering the DOD trades at 12 and 12 and a half, 12 and a quarter, 12 and 12 and an eighth, and 12 and a quarter market closes. The order is now executed. No trade took place at 12. The customer limit or lower. The order is not executed. No trade takes place at 12. The customer limits or lower. Stop order. Buy 100 XTO at 30 stop. After entry of the XTO trades with 29.5, 29 and 3/4, 30 and 30 and a quarter, 30 and a half. Orders executed at 30 and a quarter. The transaction at 30 is elected. Triggered. The stopping, making the market order. The client is entitled to the next transaction, which is 30 and a 25 quarter. Home stopping limited order, selling at 100 NXR at 45 stop. Limit entry with the order NXR trade 45 and a half, 45, 44 and a half, 44 and 3/4. The order is not executed. The trade is at 45. Elected to stop, but it then became a limited order to sell at 45. And no transaction occurred at a price or at that price or higher. Classification exchange members. There are 1,366 members, often called seats, in the New York Stock Exchange. Men and women which own these seats until they execute orders exchange floor, where they generally perform one of the four functions. Specialist number of exchange responsible to maintain orderly market, and the Security Commission House Broker member who primarily handles orders for his own firm's clients. Large firms would have many brokers on their staff. $2 broker independent members who execute orders for others. He may receive the overflow business. Commission House Broker can do floor business. The firm whose own member is not on the floor. Registered trader, a member who buys or sells solely for his own account. Order qualification instruction, time instruction. Orders that bear no time designation are presumed to be day orders expired if not filled on that day. Orders may also be entered into good till canceled, meaning they remain entered until canceled. Sometimes such orders are called open orders on the New York Stock Exchange. Only a day of the good till canceled orders may be placed in the specialist book. Orders entered within some of the other designation good through the week are entered and responsible for the entry of the broker. That the good to the week order is put in on the book, and the good till canceled. If unexecuted at the end of the week, the entering broker is responsible for canceling the order, and specialist has no further responsibility. Once an order has been entered for the day, an attempt to the extent of the duration of the good till cancel will be treated with the newly order is being entered with the significance of this as any position established by the specialist book is thereby lost, and there may now be a substantial stockhead over this order. Special execution instructions. Several special instructions may be made to add in order addition to those as far as discover the director, floor broker, handling the order to execute some manner of the normal trade. All or none, and name applies to the order where they executed entirely, not at all. Such orders are fairly common in bond trading. They may be used for the OTC stock, over-the-counter stock on the New York Stock Exchange. All or none has no standing, cannot be voiced on the floor. This does not mean that it cannot be used by the New York Stock Exchange, but the brokers accept such orders at peril. If an attempt to made to execute all or none, it might result in partial fill for which the broker would be liable. Contingent orders, either or. Two orders are entered simultaneously in the same stock. By execution, one side with either partially or completely causing corresponding cancellation on the other. Suppose a customer who had sold the 500 IKX at 100 and the shares appeared but encountered some technical support around 83. The customer might enter an order either for buy 500 IKEs at 80 or buy 500 IKX at 85 stop at good till cancel. Execution, either side would, of course, close out or cover the short position. Should the stock drop to 80 or below the limited side of the order, would be executed and the stop portion canceled. On the other hand, the stock first rose to price to 85. The stop portion would be elected. Execution would cancel the limited side, and partial execution had occurred at either price. The executed portion will be deducted from both sides of the order. For example, 300 shares have been purchased at 80. If the subsequent of the market rose above 80, but stayed below 85. Remaining party for the order would still be unexecuted. The order will be amended and read as buy 200 IKX at 85 stop good till cancel. Alright, FOK, fill or kill, the same with the all or none, except if it's done immediately with the cancel and an order is entered with the buy 500T at 61 F, fill or kill. Floor broker asks the specialist for a size or quote on T with a special response 60 and 3/4, 61, 3 by 2. This means there are 200 shares that can be purchased at 61 at once, and the order can be filled. It will be canceled with the customer being informed of such at once. Immediate or cancel. Like fill or kill, except for the partial execution acceptable, given in the same circumstances above, an order to buy 500T at 61, immediate or cancel would result in a purchase of 200 valuable shares and cancellation of the remainder. Not held, or NH. For the designation market order, freeze the floor brokers free for the judgment when execution should take place for the brokers not held to the tape of the meaning that using immediate execution of the market order may be delayed if the broker feels better price may be obtained later. Other designation with the same meaning of the not held is the disregard tape, or DRT, or take time. Note the judgment only extended the time price of the execution, not the selection, security, or the decision to buy or sell. Fully discretional orders may not be placed with the floor member. X dividend reduction on the day of the stock X cash dividend with the price is marked down by the amount of the dividend. For example, the XYZ closed yesterday at 34 and today X is at 25% of the dividend to the opening price, most likely at 33 and 73 or 34 minus 27 and divided for the dividend. Orders entered below the market and then could thus be executed as a result of the stock price down with much as such reduction not because of the market auction. Protecting of the possibility special to reduce the price of such order proportionally unless expressly told not to. The buy the limited sell stop orders will reduce by the amount of cash dividend. Should the customer wish no such reduction, he or she tell the registered representative to add or order designate do not reduce. DNR orders above the market buy stop limited sell limits are not reduced for each for cash dividends. Using the do not reduce on the orders is not necessary. Special measures handling large blocks of stocks. Normally, members of the exchange must execute the order to buy or sell stock on the exchange floor. On occasion, an order may be too large or filled with the normal auction procedure. In this case, the New York Stock Exchange may permit a member of the firm to execute the order using one of the several special methods. Specialist block purchase or sale of the or private transaction made direct with the specialist over the floor, usually priced slightly above or below the current level of prevailing on the floor. For example, suppose your firm ordered to sell 500,000 shares of General Motors in the market. Perhaps the most recent sale of the General Motors share took place at $40 to $8. However, the market may not be able to absorb the block at this large to sell 500,000 shares. It may be necessary to sell the stock down to $42 per share with exchange permission. Your firm contacts specialist in General Motors, ask him if he would like to make a specialist block purchase. Should the specialist wish to buy a block, he might make a bid at 47.5. Because of the half a point below the current price of the trading could not take place on the floor, as if it would distort the trading in the stock. Therefore, private transaction takes place in which you sell stock for your client to the specialist over the floor at 47.5. No publicity is given to the trade. It does not show on the tape displaying the floor transaction is not included with the trading volume of the stock. If the firm wishes to buy a large block of stock, it must also be done on the floor. This would be known as the specialist block sale of the transaction. Quite rare. Specialists normally prefer to sell large blocks on the floor in normal course of trading. Exchange, distribution, exchange, acquisition. The transaction usually best accomplished with a firm of the large retail branch office system, Merrill Lynch, UBS, General Motors, Payne, Weber, etc. Again, with 500,000 shares of General Motors to sell with the firm, which exchange approval informs the branch that they plan to exchange. The distribution office now solicits to buy orders from many of the clients. While the orders are able to buy a total of 500,000 shares, they are placed on the floor together with a large sell order. Firm brokers costs as buy sells agent 500,000 shares of General Motors. The trade will appear on the tape identified exchange distribution. General Manager DIST 5,000 at stock price 48. The advantage of the buyer of the stock is that they would pay a net price of 48, no commission added. The seller was placed with a held sell. He sold the stock at the current price level rather than forcing the price down with a large block. He would buy and pay a large usual commission, allowing for him to compensate those solicited to the buy orders. An order with a buy large block procedures example exchange acquisition would identify with a tape display as the letter AQ. Special offer, special bid. Special offers allow the member to employ with the sales ability other members, firms distribute large block of stock. So the firm had 600,000 shares of Dow Chemical to sell to a large institutional client. Might exchange approval to elect to make a special offering these shares of the New York Stock Exchange floor. An announcement would appear on the tape setting the Burns, Stearns & Co. making a special offer of 600,000 shares of Dow Chemical as $40 less special commission of $80 per share. Registered representative some of the other firms seeing the notice you might obtain with the order from one of the customers to purchase 200 shares. The order will be given to your broker, who would go post it where Dow is traded to buy 200 shares of the Bernstein broker at 80 net. Your client would pay no commission and your firm would receive $80 per share from the Bears and Stearns. The transaction would appear on the tape as Dow special offer 200 shares at 40. Each transaction displayed until the broker else sold with withdrawn with the lack of the interest the seller would obtain with the current market price rather than forcing the stock down, would pay larger than usual fee for the service. If the order was to buy a large block, the procedure used would be a special bid. Secondary distribution. Secondary distribution is the sale of a large block of steel off the exchange floor, generally after the close of the market, in which exchange non-members may participate. Secondary, the most often used method, distributing large blocks, but depending on the identity of the seller of the offering, may have it registered with the Security Exchange Commission before the sale can be made. The seller of the affiliated person on one who can influence the corporation policy, Security Exchange Commission registered would be necessary. Note, Rule 144 would be discussed detailed with the earlier section permits some of the sale of these persons to be made without registration. The secondary may be registered and non-registered depending on the particular case. An investment banking that would hand over the secondary distribution of the seller of the block of the cousin extremely large block may put together with a group of the firms underwrite their offering called the syndicate. The group would include firms that were not members of the New York Stock Exchange. Secondary would announce on the tape Goldman Sachs Group Incorporated is making secondary distribution of 1 million shares at IBM, 91 less than a special commission of $1 per share. Unlike the special offer, this was done in the New York Stock Exchange, would be handled off of the floor with Goldman Sachs Groups Incorporated offer. The interest would contact Goldman Sachs Group Incorporated in an attempt to buy 91 shares at $91 net to the clients less $1 per share. Concession of the firm ordering the order of secondary distribution usually done after the market closes, but sometimes done during the regular market hours. These are called spot secondaries. Role of specialists. As noted, the specialist is a member of the exchange that is responsible for maintaining an orderly market and security. With the term specialist is indicated with the firm itself as well that the individual member to handle the trading of the shares in which the firm specializes. Specialist firms are large and well-capitalized organizations. They do not often deal with the public, and their names is not as well known nationally as, for instance, UBS, Payne, Weber, Merrill Lynch, Morgan Stanley. However, the large specialist firms such as LeBranch & Co., Spears, Leeds, and Kellogg are major financial organizations that will handle more different security specialists will control individual exchange members. In performing functions, specialists act for the two capacities of the broker agent, wherever they execute with entrusted him, with the other form of the principal dealer, wherever the buyer sells with his own firm's account. When acting agent, specialists accept the order of the firm from member firms away from the current price of the found stock company. and Company had ordered 2,000 shares of the General Motors at 48. When the last sale of the General Motors was 850, it would not pay to waste the broker valuable time by having him stand at the post waiting for a decline in price. They would send that order to the specialist, who would place the order on the books should the stock decline at $48. Specialist would buy the shares, report the purchase to FanCom. At the end of the month, the specialist would send a bill for the floor brokerage charge for executing the order. By limited orders, virtually all stop orders are given to the specialist. And by busy market, the specialist might also be given market orders that the firms find themselves unable to handle. When acting as a broker, specialists do anything originating that can do in the executing order. However, the acting with the principal, some of the restrictions are placed with the activities. The specialist private the information that rests on us do not have such for the number side of the size of the order of the books, who would otherwise have an unfair advantage over us. A restriction specialist acting as a principal specialist cannot bid offer the same side of the market order he is holding. If he gave the specialist an order to buy 200 shares of the Scott paper at the market, the specialist cannot bid at any price for his own account until the order was completed. He would, however, sell the stock holding the buy order as would be opposite the side of the market. Specialist cannot bid offer on the same side of the same price for the limited order he is holding. Suppose the specialist quoting an Eastman Kodiak at 25.5 up to 1,000 up, and this means the best bid of the Kodiak was $25 for 1,000 shares of the best offer at 25.5 for 100 shares. Assuming the buyer ordered at $25 was given to the specialist Beersteins and Company, and sell the order at 25.5 was given by him to the Morgan Stanley. While he holds limited orders, he cannot bid 25 or offer 25.5 for his own accounts would be competing with the customer orders. Note the specialist can bid or offer between the prices that would improve the market. There is an example. Specialist be free to bid and offer a price between 25.01 and 25.24. Specialists cannot cause the election stop order. Noted that earlier stop orders or memorandums ordered will become market orders with stated price for each of the surpass. With IBM trading at $91, 91 customer placed an order to sell 100 IBM at 85 stop. The order is placed with specialist books memorandum. Should IBM decline when the price of the trade at 85 or lower, stop would be elected triggered. The specialist would now sell 100 shares of the best price available, as only the specialist know of the existing and stopping orders. He could take advantage of the situation. If there are many thousands of the shares of the buy, the sell stop particular price, the could elect for the orders to simply buy or selling 100 shares of this account. This would execute the order to market the receive of the floor brokerage. Might even adjust the position at that time without taking advantage of the market's reaction. Elected stop order therefore cannot cause the electing stop order. For example, sell 100 IBM at 91 stop. The specialist cannot bid offer his own account at 91 lower successful bid offer the elected stop. No stop orders tend to collect for the same price, but frequently due to the technical assistance study related to the same conclusion. Thus, when two of the stop orders enter for the same price for the election, disrupt the market for the reason exchange that often ban stop orders to prevent their distributing orderliness of the market. Specialists cannot broker any or deal same transaction. If the specialist wishes to buy or sell his own account, he cannot also act as an agent for the firm on the other side of the trade. Specialists were given an order to buy 100 Exxon after the market wishes to fill the order by selling the stock of his own account. He would have to summon a broker for the firm which the buy order returned order to him. He could sell the stock as a dealer principal, while the other firm's brokers would present it on the buy side. Specialist cannot stop stock from its own stock. Cannot stop stock for his own account. Stopping stock is a procedure with a specialized guarantee to preserve stock at a price given the broker opportunity to improve the price. For example, the broker of the Prudential Securities has an order to sell 100 KYZ at the market. Upon arriving at the post, he told the specialist that the stock is quoted at 78.79. Broker knows the indicator above the post. The last sale of the XYZ was 79. Broker has a problem. The best price bid at which he can sell the stock is 78, which 1 point below the last sale. This will not please the client if the broker attempts to better the price. If he runs risk of missing the market, should the broker later be forced to sell below 78, he would be reasonably for the difference in price. Responsible for the difference in price. In an attempt to solve the problem, he said the specialist will stop at 78. If the specialist agrees with the president's broker can relay the specialist guarantee to him that he will not sell below 78 with the best price currently available. The specials will then give the order. He will offer the stock above 78, perhaps 75, 8.5. If the buyer comes to the proposed prudent order to be maybe filled with 78.5, but in no case will the shares be sold below 78. The special is guaranteed by stopping the stock to fill. The guarantee for the specialist may have to buy the stock himself, but he will stop the stock on many occasions to prevent, if possible, large variation in price transaction. Note when stop stock trades is printed in the tape identifier with a T, S over T, which shows the transaction previously guaranteed by the specialist. This is done to prevent some of the other client from feeling that he was entitled to the transaction. Should the stock or the example eventually be sold at 78, it would show on the stock day XY 78 stop stock. Short sales. Short sale is defined in security exchange as a sale of security which you do not own, or if you own it, you do not intend to deliver it. The mechanics of short sale discussed in detail Chapter 8, Federal Reserve margin. The short sale of the investor sells borrowed security with the hope of buying them back in the future at a lower price. However, there are a few prerequisites before short sales can be completed. It may be executed with the customer margin account. 2, the order must be market short. 3, he must be able to borrow the securities he is selling short. His broker will provide this service. New York Stock Exchange bond activity exchange recognized the market over the bonds is often better than the over-counter market. For the reason the permits member firms execute orders at $10,000 face value of the bonds off the floor of the exchange. Orders calling the amounts of $1,000 to $9,000 can be executed over the counter under the exchange of the non-bond rule if one or more of the following conditions exist. Customer instructs the firm to execute orders off this floor. In this case, the firm can act only as an agent. Order the U.S. government municipal bonds. Bonds have been called within 1 year of the maturity after careful check of the fair market does not exist on the floor. Tape display transaction stock is shown continually during the trading day, or what are commonly known as ticker tapes. The names goes by with the early day as over the tape invented by Thomas Edison. The tape made a clicking sound as it progressed. Thus, each transaction is called a tick. Today's tape business is in 2 separate systems. Consolidated tape shows the transaction stock listed with the New York Stock Exchange. However, they show the trades in stocks wherever they may occur. Thus, the GM on the tape may have been taking place on the New York Stock Exchange. Also occurred on any other stock exchange as well within the third market, which over-counter trading. The exchange listed stock consolidated B. Tape B shows the transaction stock listed in the American Stock Exchange that occur on the exchange. On that exchange in any other market. When the trade occurred, the stock is shown on the tape. The symbol of the stock over the transition principle indicated the volume of the traded transaction, 100 shares only. Symbol of trade price, for example, the trade 100 share of the Texas Instrument at 37.5. Trade share of the 299 shares using first digits of the volume of the letter as appearing between. So the trade at 700 Texas Instruments. At 37.5 would be TXS over the 7, volume of the letter 7 with the 37.5, trade 9,500 Texas 25.5 would be Texas Instruments 95 at 37.5. Trades of 10,000 shares or more should show the volume figure again with the letter S between the trade with the 10,700 Texas Instrument at 37.5 and appear Texas Instrument at 10,700 at 37.5. Should the volume trading call for the tape that run late, generally 5 minutes or more, the announcement digit deleted will appear with the time. Will then print out the only last digit price or 1,700 share traded at Texas Instrument at 37.5. Further delays will cause digits deleted to announce that the trade would be appear at Texas 7.5. Although most of the trades of the 100 share units rounded lot, some stock with the New York Stock Exchange 10 share round lot, the stock is primarily listed at post 30, where the inactive stocks are traded with the round lot trades are 10 shares or units identified by the letters S over S appearing between the volume of the price. Trade of 1 to 400 share of the XY with the PR at 165. PR is the symbol of denoting preferred stock, whereas would appear XY preferred stock for 400 shares at 10 shares rounded to lot at $165. Traded 60 shares of the XY preferred stock would appear as the XY preferred stock, 60 shares at 165. Exchange is 10 for the print transaction on the tape of the order, in which the order are sometimes impossible to do with mechanical human error. In this case, the sequence task are identified as wholesales by using the letter SLD. If the following trades U.S. steel were shown on tape, X at 130, X sold 113.35, X 113.12. We would know that the second transaction was not shown in proper order, but the no continuous should be drawn with a sequence. When the market opens on each day, but the transaction begins showing on the tape, the particular stock opens late, more than a half an hour opening. The opening of the price sharp, open or down from previous closing open trade would be identified with letters OPD or open. The price change of the would call for the use of the symbol as followed, where the stock closes at $20 per share. Change for the next morning, opening at 1 point or more. For the closing at $20 or higher, the changing 2 points or more. So as Teledyne closes tonight at 44, should open tomorrow morning at 42 or 40 lower, 46 or higher. Symbol open will be used. Let's say that tomorrow 2,700 shares of Teledyne opens at 46.5. It would appear on the tape of the Teledyne opened 2,700 shares at 46.5. This call attention to the stock that may leave to make inequity and a better service, or clients note with the stock listing exchange of the symbol to no more than 3 market characters. IBM is as long as they get symbols over the counter stock, where it will be discussed later for 4 more characters. Their symbol, for example, Core FICR. National Association of Security Dealers over-the-counter market. The National Association of Security Dealers found with the Maloney Act Amendment of the Security Exchange of the 1934 Amendment that passed with the Congress 1938 allowed the establishment of the Securities Association to regulate over-the-counter market. The National Association of Security Dealers formed in 1939 authority over the counter market similar to that of the stock exchange, regulating the members of the market. Any broker-dealer who transacts branches of the investment banking security bond business in the United States is eligible to join the National Association of Security Dealers unless subject to one of the following: where the broker and dealer has suspended, expelled with the National Security Exchange for violation of equitable principle of trade with the Security Exchange, where the Security Exchange, any stock exchange, had an order revoked and denying registration of the broker and dealer, where the individual do not meet training experience with the other standards of the National Association of Security Dealers Board of Governors may feel necessary, where individual convicted with the last 10 years felony misdemeanor with involving investment, misappropriation, funds, abuse, fiduciary relationship, the take on added importance because of the National Association of Security Dealer members of the advantage of the price of the concession, the discount of the underwriting allowance. National Association of Security Dealers rule of the registration principle, the representative of the main class of the principle, the general security principle, financial operations principle. The National Association of Security Dealers require that all corporations and partnerships have at least 2 persons registered as principal. The following individual must register the principal person and engage with the management, supervision, personal investment banking, security business person involved in the training of the principal personnel of the member. With us, these would normally use the registered principal, sole proprietors, partners, or officers, managers, and officers of the supervisor jurisdiction, directors, managers of the investment of the banking activities, and training directors responsible for training above. Since September 1st, 1972, every broker-dealer must designate a financial principal who will be responsible for preparation, proof of the financial statement, and net capital computations. Qualified financial principal for the person must be written examination unless specifically accepted by the National Association of Security Dealers. Term of the registered representative identified by the National Association of Security Dealers as every partner, officer of the employed, a member engaged in any of the following activities: 1. Solicitation, handling, listing unlisted security business sales, listed unlisted security for the agency principal basis. 3. Solicitations of subscriptions, service provided the fees based on the size of investment management advisory services for trained registered representative. National Security Dealers has certain limited categories. Registration of the person who sells within certain investment products engaged in a specific area of the activity. Limited categories include one investment company, variable products representative, the direct participation program representative, the real estate security representative. The individuals except for the registration, foreign associates if they are not U.S. citizens, residents who do not transact business, U.S. citizens, and residents. Other employees who exempt just engage clerical ministerial functions, that whose participation nominal money partners who that work on the floor exchange, those would handle only exempt securities and commodities. If the person associated with the member voluntarily reassigned with formal resignation address for the national security dealers in writing, the National Association of Security Dealers will immediately notify the member such for the resignation will not take effect until 30 days after the receipt of the resignation of the National Association of Security Dealers, or so long as the complaint and action pending against the person. However, the National Association of Security Dealers may add its discretion to declare the resignation effective at any time. The Association of Security Dealers members must also give the written notice to the National Association of Security Dealers for registered representatives terminated no later than 30 days calendar days after the termination. Further, anyone guilty of submitting the membership of the registration application of misleading any of the member failed with the register of the employee who registered is the subject of the disciplinary action by the National Association of Security Dealers. The National Association of Security Dealers regulations separated with the 4 category codes: conduct rules, code of procedure, code of the arbitration, and uniform practice code. Conduct Code. The Conduct Code are considered the day-to-day operation securities of the firm, and they contain the most important section of the Conduct Code rule are numerous, but they are not covered in entirety here. Reason being is their Series 7 exam question of the designated acts of knowledge of the entry level of the registered representative. Police do not take the statement to mean that you can take section lightly. On the contrary, the items discussed below will be tested with their various section of the conducted rules, even though the real numbers are not tested. The content must be understood and implied. One section deals with the business conduct. Members touch of the advertising requirement. All advertising submitted by the National Association of Stock Dealers for approval of 5 days. Further, use one exemption of the status of the advertising regarding investment companies must be submitted within 3 days after the first use. Advertising includes any material used for the media, newspaper, the magazines, radio, television, recorded telephone reports, motion picture advertising, exclusive with the definition of advertising, so-called tombstone ads, announcement of the new issue of the office, opening of the personal changes, sale of the literature, that include the research reports, market letters, and such, not to be submitted to the Association of Security Dealers for approval. That must be approved by the principal of the firm. The firm must also maintain a separate file of advertising sales literature for the 3 years of the purchase, sale of the equity, of the IPO, of the discussing of the coverage new issue, also including the section conduct rules. Please review the provisions of Rules 27 to 90 of the Chapter 4. Another section requires that you have the reasonable grounds to believe that the recommendation is suitable for the customer based upon the facts and scope of the customer concerned with its own secretary holding financial situation, need of providing its furnished such information to you. Further, it prohibits the following practice under the policy of the fair dealing, recommended speculative of low price securities without regard to suitability, churning, the trading, mutual fund sharing, fraudulently actively recommended in purchasing customer financial means. This section prohibits the member with any of the person associated with the member to directly or indirectly give the gratitude of the gift exceeding $100 per individual per year. Any person who would represent another person the payment with the gratitude in relation to the business of the employer of the recipient of the gift of the section referred to require a separate record of all the payment of gratitude for any of the amount retained by the member. It's a violation of the conduct rule for anyone vested with the discretion of the account with the church and term the account, but this also prohibits the discretion of the customer account unless the customer has given the prior written authorization. Account has been accepted by the member with approval of the writing by the member of the partner, officer of the manager designated by the member. Further, the member of the person designated by the member must be approved of the discretionary order properly, must review all the discretionary orders frequently in order to protect the transaction from transactions that might be considered with turning with regard to the rule of discretion price for the time does not apply. It is also prohibited manipulative, deceptive, or fraudulent devices and due to the purchase or sale of the security by a client. This section prohibits the member of the guaranteeing of the customer against the loss of his account. However, the main thrust of the section of the prohibited making improper use of the customer's security funds without written consent of the client. The firm may now borrow for the lead and lend customer securities. Normally, they would pledge and hypotheticate the use of collateral loans of the brokers and dealers no matter more than customers for the securities. They might be considered fair and reasonable in view and indebtedness of the customer to the firm unless such member to receive the prior written authorization client designation particular securities to be loaned. Further sections prohibit any of the person associated members sharing with the profit or loss of any of the customer except with the prior written permission of the member firm providing the shares only with a direct portion of financial contribution and personally made the account. Another section requires each member to keep the preserve of the records of the documentation conformity with all the public rules, laws, regulations, policy with the National Social Security Dealers. Each member must also maintain record of the customer to show the following name, the address, web of the customer's legal age, signature, registered representative of the individual accepting the account with a member of the customer associated with another member. The fact that it must be noted the account with the discretionary, the age, the approximate age, the occupation of the customer. Finally, the section requires the member to keep the preserve of each of the office supervisor jurisdiction separate file with the record all of the written complaints of the customer or action taken by the member. If any is satisfied with the complaint, members are required to allow bona fide regular customer to inspect upon request for the information relative to the member's financial conditions disclosed in the most recent balance. Members may grant, receive, selling concession discounts to other allowance of the connection with the sales security of the part of the fixed price offering. The consideration services rendered with the distribution only to the brokers and dealers actually engaged in the investment banking security business. It also stated that the member is not prohibited from selling security stated public offering price person to whom the provided bona fide research in order to grant selling concessions, discount, other allowances to apply. The person must obtain a written agreement from the person that he will comply with. Provision Rule 2790, if the member grant with a concession discount with the allowance with a non-member for the deal, a broker to deal with a foreign country, then must also obtain with the broker to deal with a written agreement to comply with the various provisions of the form with the broker to deal with a member of the National Association of Security Dealers. Section prohibit the member for the dealing with a non-member for the any of the term of the would deal with the public of the provision of the section and apply with a non-member the broker to deal with a foreign country who's not eligible for the membership of the National Association of Security Deal with apply with exclusively with the activity of the member of the connection sale with the open ended investment company shares. No member may offer the sale of the share of the open end with the investment company with the public offering profit included the sale charge for the excess of the taken into consideration relevant circumstance. Sale charge will be considered except for if they do not form the following: 1. Maximum sale charge any of the transaction cannot exceed 8.5% of the offering profit. If the fund does not offer the dividend and reinvestment, the maximum sale charge is 7.25% of the right accumulation does not made available. The maximum sales charge is 8% of the fund with the offering for the dividend reinvestment 6.75. If it doesn't, right accumulation permit and reduce the sale charge if the future purchase of the new breaking point is reached. 4. For the quality discount breaking points are not made available, the single purchase of the maximum sale charge is 7.25 for the funds offering the reinvestment right of the accumulation. 7.25 off of the dividend reinvestment, but not rights for the accumulation. 6.25. If the offer of the accumulation but not dividend reinvestment, 6.25 of the neither really accumulation, dividend reinvestment. The rule further prohibits the member for withholding the customer order for the investment company security of the result of the profits with himself with the result of which such withholding. The member may only purchase share of the investment company but already with the purchase order and in the possession of his own investment account. Mutual fund shareholders may also have his shares redeemed by investment company net asset value. Some of the fund charge redemption fees 1 to 2% of the technical exemption of the shares must be redeemed by the fund within 7 days after they are tendered. Further, no member may be permitted to favor of the distribution of particular investment company shares on the basis of the brokerage commission received expected with the received from any source included with the investment company. However, the members who sell the investment company shares are permitted to execute the transaction for the investment company as long as the such orders are not obtained on the basis of sale investment company share. The section of the conduct rules set forth in the supervisor requirements. Each member must establish, maintain, enforcement, written procedure to enable the supervised properly activity to a registered representative. In addition, with the registered representative associated personnel are required to comply with appropriate security laws, rules, and regulation. Responsibility, provision, supervision rests in members of the designated partner, officer, manager, and each of the supervisor jurisdiction carry out the written procedure. These sections conduct rules such for the complaints and may also be against the National Association of Security Dealers. Member or any other person associated with the National Association of Security Dealers by a public customer business conduct committee with the National Association Security Dealer Board of Governors, National Association of Security Dealers, and the Security Exchange Commission. Member of the person associated with the member required with the District Business Conduct Committee with the Board of Governors do authorize agent of the committee with a report orally written concerning any of the matter and investigation testify at the hearing. National Association of Security Dealers must also investigate the books record with any of the member relating to the investigation at the hearing. No member of the person associated with the member of the review of the permit inspection of the book of the records failure to furnish the reports requires National Association of Security Deal with the constitute with the ground of suspension after 15 days with the notice for the writing continue with the furnish of the information required by the President of the National Association of Security Dealers authorized on the behalf of the Board of Governors to suspend a member of the person associated with a member. This section conducting rules state that the member of the person associated with a member to be censored, be fined up to $15,000, suspend with the membership of the registration, expelled with the registration revoked, be barred from the association with a member, or be given any other penalty appropriate under circumstance of the member is also prudent for the paying any sale or commission for the result of any security transaction earned during the period of suspension of associated person. Every member is responsible for keeping and preserving the appropriate record of the caring of the member. Supervisor proceeds with the member. The authorized representative must review and endorse writing an internal record. All transactions correspond to the registered representative pertaining to the solicitation, execution, any security of the transaction. Member of the organization, member of any other registered principal must also review the activities of each office, including periodic examination, customer accounts, detect for the prevent irregularities or abuse. At least once a year must conduct an inspection of each office of supervisor jurisdiction. Under the section of the National Association of Security deal with the Board of Governors has also interpretation cover the private security transaction purpose of interpretation of private security transaction many securities transactions not supported by the firm involved with a limited number of purchases to sell the contrasted with the public offerings registered with the Security Exchange Commission. Other investment transactions involving the associated personnel that mislead the customer into believing the transaction are sponsored by the member. Obviously, these types of transactions are prohibited. The conduct rule also requires the employee of one member to seek an account with another member. The second member must notify the persons of employer promptly when the writing member carrying the account must exercise a reasonable diligence to determine if the transaction would adversely affect the interest of the employing member. Additionally, the risk requires the employer to receive duplicate copy of the confirmation or a monthly statement of the carrying member relating the transaction of the employee. Section prohibits the member of the offering selling variable annuity with the payment. It includes sales over the unfair tax consideration relevant circumstance variable annuity to be not offered sold other than value determined after the receipt of the payment according to the provision of the contract. Payment is not considered to have been received until the contract has been accepted by the insurance company. Section also requires the member permanently to transmit issuer all applicants variable annuities at least part of the paying part of the purchase payment that will be credited forward to the contract opposed to part payable to the sales lead. Lastly, the rule provides that the member may not participate with selling variable annuity unless the insurance company may prompt payment of the amounts requested and paid with the under the contract presented with the proper request for the partial total redemption. Code of Procedure of the National Association of Security Dealers for the chapter of the Code of Procedure of the Handling Trading Practice of the Complaint regarding violation conduct of the rules adopted there under codes provided with the District Business Conduct Committee with the National Association of Security Dealers to hear to pass on all of the complaints regarding violation of these rules. The Board of Governors of the National Association of Security Dealers acts on appeal for the court to review the deep body, but it does not handle the over original complaint, the initial complaint, with his initial response with the complaint, with the may request for the hearing with the District Business Conduct Committee is entitled to such a hearing with the absence of the source for the request for the hearing. The committee is used itself with the may order with the hearing when it does deem such an action necessary and appropriate for the hearing, both as the complaint respondent entitled to the hearing in person to represent the council submitted the relevant matter and the desire to present indicate for the District Business Committee with the belief of the facts of the matter but not in dispute with the acts of the practice of the conduct involved with the council to a constitute violation of the conduct rule following regular complaint procedure that do not appear to be appropriate to the committee, but they may offer the respondent an opportunity to waive the hearing except for the summary of the complaint proceed with the industry of the summary complaint proceed with the penalty. All violation alleged cannot exceed censure and a fine of $2,500. The respondent in a hearing before the District Business Conduct Committee may at any time propose the writing of the district security to in order to set order of the settlement. The district secretary must submit such an offer to the committee with the initial cap over the initial cap settlement may be made at the time during the course of the proceeding, but may be made in conformity with the provision of the conduct rule of the offer may be frivolous or made or proposed a penalty inconsistent with the sense of the violation to be found when any action taken by the District Business Conduct is subject to review by the Board of Governors on its own motion within 45 days for the day after the day of the notice upon the motion of the aggrieved person providing such motion is filed within 15 days after the date of notice. Any case for the whether the complaint or respondent feels aggrieved by any disciplinary action taken and approved of the Board of Governors, either the party may make an application for the reviewed and security exchange in accordance with Section 115A Security Exchange of 1934. Code of Arbitration, National Association of Security Deal. The Code of Arbitration proceeds with the draft of the arbitration controversy arising out of the security-related business, and a member of the Code of Arbitration proceeds handle the dispute of the controversy between any of the members and between members and public customers, between members and clearing corporations, clearing banks, and associated banks. Any disputed claim in the controversy subject to the arbitration under this code must be submitted to arbitration in the circumstance. In the instance of the member against another member, in the instance of the public customer against the member and or person associated with the member, in the instance of the member of the NCC division of the Depository Trust Clearing Corp, Clearing Bank, and Associated Bank, and against any other, an issue with the member against the person associated with the member, with the person associated with the member, and person associated with the member against member, in the instance of the person associated with the member against any other person association with a member. Uniform Practice Code of the National Association of Security Dealers designed to standardize the practice employed by the dealers making the selling transaction. The code is supervised by the Uniform Practice Committee except in certain securities, U.S. government securities, municipal bonds. Let us make an important section of the code. Delivery date, four type of the trade for the Uniform Practice Code. The regular way, RW trade sells on the third business day of the trade with us, so the broker sell the securities with another broker on Monday, May 7th, the regular way basis. Seller delivers security for Thursday of the May 10th, at which time the buyer must prepared to make a payment. Regular way trade, U.S. government securities are settled on the first next business day after the trade. Seller options trade settled with the third business day of the 16th of the calendar day after the trade. The condition of the trade must be agreed with the time of the trade is made with that. For example, the client broker wishes to sell the stock for the day, but it does not have the physical possession of the certificate. Perhaps the daughter's home some distance away. He cannot get them for 3 weeks or so. But the home and the broker could offer the securities to the seller at 25 of the buyer accepted with the term to deliver. Would not require the seller and broker until the 25th calendar day after the trade of the client and sold the shares today at 25 days to deliver. Suppose the client's unexpected to obtain the possession of security sooner, but it has been anticipated with perhaps the 10th day of the trade. In this case, the selling broker could deliver the securities either earlier than stated by the original trade by giving the buying dealer 1 day with written notice. Cash trade, the trade settled on the day of the trade with the client when they have the merchant need the money. Immediately the broker offered the securities for cash. Should someone accept the offer under the terms of delivery and the payment would occur the same. This would allow the client to obtain what it needs for that day, but the natural securities must be deliverable with the cash trade to make it impossible. The buyer-seller option cash trade seller may have the sacrifice of the price. Buyers accommodating the seller with a may charge of the accommodation dropping of his bid. When issued, when WI trades the actual name of the when as if issued settled on the sum of the understanding future date. Perhaps the new issue of the stock of the bond is made at time offering. The actual certificates may often pre-printed with the particular of the truth of the bond offering coupon rate is not determined by the offering of the date. But in this case, we began the trade stock when issued with the manager of the syndicate with the provider with the settlement day. Though when as if issued may occur with the stock splits. When we began the trade, the stock with when issued, the National Association Security Dealer Uniform Practice Committee can give us a final settlement date, a close relative with when issued, the distributed. When distributed, the result of the spin-off company A owns company B. We decided to give the B shares to the holders of A stock. This is known as a spin-off. We begin the trade company B stock as soon as the arrangement of final again with the physical certificate may not yet be available. We trade when distributed until the new shares are ready. X dividend, X rights, X warrants. When corporation declare for the cash dividends for the issue of the rights of the warrants to their shareholder, the corporation determine the record date for the distribution record date of the day of which must be on the books of the corporation within entitled the dividend of the buyer security to become the record owner with the settlement on the day of the trade. Therefore, the regular way to trade must be made within 3 business days prior to the recorded dividend with the buyer with the entitled the distribution. If the purchase stock with a 2 business day prior to the recorded date, you would be too late with the receipt of the dividend settlement date with 3 business days later, but would after the recorded date trade made on the X date permitted to seller retain the dividend if it is too late with the buyer to perceive it. This is also true with the distribution of the rights, warrants, and other items. Cash trades settle on the same day as the trade. Therefore, security brought on the cash on the recorded date with entitled the buyer to perceive the dividend. Thus, the cash trade of the X dividend on the business day following the recorded date should be kept in mind with the X date of the rights and warranties under normal condition of the day after payment of the day. Alright, good delivery. Good delivery is one of the buying dealers is required to accept the security of the delivery settlement with the transaction buyer inspection will comply with the Uniform Practice Code of the good delivery buying dealer must pay for them. There are a number of that are necessary to good delivery, including with the varying denomination bond style constitute with the good delivery, the reasoning that they are still blocked from the books in the National Association of Security Dealers according to current outline of General Security Registered Representative Examination Test Series 7, Section 621, page 19. They can be still tests on them. However, physical delivery security is almost not inconsistent with these days. Therefore, known that they exist, they do depend too much on time on this area. When a dealer makes a delivery settle of the trade, the most conform to the certain requirement of the denomination certificate of bond transaction delivery must be with the denomination 1,000 multiple thereof. The acceptable would be bonds of the $500 denominations. For example, the Morgan Stanley $10,000, the KYZ debenture Burns and stock. Morgan Stanley could deliver the combination of 1,000 denomination bonds multiplied by the 1,000 or $500 face value. For example, the following would be for delivery of the 10,000 bonds or 10M. There are many other possible combinations, but these goods delivery bond, the denomination mentioned for the goods delivered need not to be accepted for the purchase dealer. Therefore, for example, the 10M bond trade would not be deliverable. These odd denominations are called baby bonds, which sold with the designated as such of the price bond paid usually below the bid of the bond with the acceptable denominations. In stock trade of the good delivery of the round would be 100 share certificate multiples of 100 H.E. Edward Son with the sells 400 share of the top of the born Stanley A.G. Edward could deliver 400 share certificate and 2 shares of certificate and 100 shares certificates also consider the good delivery of round lot stock trade would all old odd lot certificates be assembled into $100 share amount. This means the buyer must take odd lot pieces of that can be piled up into $100 share piles. For example, on a 400 share trade, Edwards could deliver either 50 share certificates, 20 share certificates, or 401 share certificates. All these assembled and piled up with 100 share amounts as proper combination round odd lot certificate good delivery. For example, a 400 share trade allowing the acceptable. It would not be delivered with a seller delivered 5 certificates for 80 shares, although certainly with a 40 and 80 share certificates cannot be combined into 100 share amounts. Odd lot stock trade sellers may deliver the number of certificates as long as the total exactly matches the trade operation. 40 stock shares to take place, but the seller could deliver 40 shares certificate for $10 shares to 10 share certificates and 20 share certificates. However, the buyer need to accept the delivery of 50 shares on the 40 share trade, nor a 30 share partial delivery. The deliverer must be precise at 40 shares. Suppose we have the combination round lot odd lot for say with a 440 share. The easiest way to approach the separate is 400 shares at 40 share. The good delivery would be able to segregate the odd lot 40 remaining certificates must satisfy when it's rounded a lot of 400. The following would be good delivery of trade 440 shares. No, one of the on the above when using 8 share certificates odd lot, each remaining 5 shares would be combined to 95 share pieces, resulting in 100. Following would be a good delivery of 440 shares. Registered versus bearer securities. Securities bearer form that do not include the name of the owner. The bearer securities is like a $100 bill, whoever has it owns it. The delivery of the bearer securities is considered good as long as not mutilated. The bearer bond with some of the remaining interest coupons torn off into the not good. The bearer stock certificate instinct obliterated. Some of the details is not good. On rare occasion, the mutilated certificate is good delivery authenticated by the issue company and agent, transfer agent, register, etc. Registered securities are there bearing the name of the registered owner. Required properly completed the assignment, the power of substitution, the proper name for the bearer for the back of the certificate, which must be completely signed registered owner with the often separate assignment with the power of substitution, which is called the stock power and the bond power. Simply fasten out back of the certificate used for the purpose of the safety convenience. The assignment that must be signed with the owner exactly his or her name. The bearers on the certificate. Certificate registered Roger T. Jones should be signed with the Roger T. Jones. If signed R.T. Jones with the dealer delivering the certificate must place the stamp under the signature guarantee that one is the same person. The dealer must sign with the guarantee of the name of the person chained with the sign and with the certificate. Since the certificate usually was due for the marriage and divorce, the certified registered Mary A. Jones might now be owned by Mary A. Smith. A woman's married name, she would sign both names and delivery hand. Delivered with guarantee to be one of the same person. Security registered with the joint accounts must be assigned by all tenants. Should you have the security registered name of the 5 tenants for the fill. 5 must endorse and order a certificate of the good delivery in case of the signatures assignment must be guaranteed by the broker and dealer bank. Keep in mind that the buying dealer does not know the person with whom the certificate is registered by having signature guaranteeing the buying dealer safe their forgery, other impurity. Bearer securities are still around, but corporation municipalities have used them in several years. Eventually will disappear in nature. Wow. All right. Legal items. One of the required the supporting documentation, perhaps the security was sold with the registry with the name of the deceased, perhaps the accomplished transfer with the security with many of the documents with need for the transfer engaged with the various some of the degree, but would accept the employment of the exact state the execute of the administrative of the court jurisdiction would be necessary. In addition, the tax rate of the affidavit is domicile of the instruct regarding the disposition of the asset of the execute of the administrator who would require for the transfer of the ownership of the securities would not be proper to play with the burden of the problem of the dealer purchasing the security of the sealer and the dealer with the accomplice transfer of the delivery securities. and the street name of the broker-dealer name too of the buyer. If the buyer should not be expected to accept the dealer's security for the present of the transfer problem, the problems should be solved by the agent. Seller of the security delivered by the buyer should be readily transformable form. Other examples of legal items would be with the name of the executive, the administrator of the trust, receiver of the other registrar of the would play for the unnecessary burden on the buyer who buy only stock with not any of the problems associated with it. Due bills and due bill check. The due bill is similar to the IOU issue when the selling dealer delivers the security to the late with the accomplished transfer the name of the buyer with which cash dividend and other distribution eminent. For example, April 4th, the corporation declares cash dividend of the pay of the stockholders recorded Wednesday, April 11th. The buyer of the stock of the April 4th would entitle the dividend with the trade would settle with 3 business days later, April 9. Before the recorded date, it would be unlikely the stock even delivered April 9th could be transferred at the time of the dividend paid for the right recipient to the buyer with the avoid unnecessary paperwork. The seller delivered securities accompanied with a due bill for the amount of the dividend on the payment day. Buyer simply prints the due bill into the seller with the collected amount within which is entitled to save even further problem. The select might use the double bill check. Due bill check. This symbol and check with the amount the due of the buyer carrying the date coincide with the payment due day of the dividend. Due bills can be used as a substitute for any item which the buyer is entitled to, but which the seller is unable to deliver. For example, the use of the substitute with the stock dividends, stock splits, rent, rights, warrants, other distribution that are due to the buyer that the seller is not in position to deliver. Due bills and due bill checks are rare indeed. This is occasioned by automated clearing transaction via the depository trusting clearing corporation. Buying and sell out. So the two dealers are party security transaction assume an obligation from the uniform practice code that required complete settlement with the transaction on the term of the contract. Example, the regular way of the transaction. Stock with the seller required to deliver security for the third business day following the transaction. The buyer must be paid with the proper payment of the day on that day. So the either party of the trade with the failure to perform obligation, the other party has access to the procedure to protect the rights. Should the selling dealer fail to deliver required with the buyer implement procedure known as the buy-in, the deliver is now made as required with the billing dealer after giving 24-hour notice. It can repurchase the security charge at any of the price difference lost to the defaulting seller. For example, trade occurred at 100 share of the Acme fashion with the $22 seller does not deliver by the time the buyer sends the buy-in notice. If the no response is received 24 hours, the buyer simply repurchases the stock, perhaps at $25-30 per share, in charge of the difference to the seller. On the other hand, the seller makes a properly delivered. The buyer refuses to pay the seller. The procedure called the sellout. When the delivery has refused, the seller immediately, no 24-hour notice required, would sell the stock and charge any difference in price lost buying dealer who did not live up to the contract items. But please note that the procedure available to dealers or party in trade that are usually used the first opportunity available should the dealer have concern regarding completion transaction. Mark to the market. A mark to the market is used to adjust the value of the securities borrowed and owed. Example: the dealer buys 100 shares of shares of stock from dealer B at $50 per share. Trade is made on when issued the meeting, and the dealer B cannot deliver the stock. It has not been made available during the time the contract remains incomplete. The stock may rise per value price $60 per share. In the case of dealer A and can send dealer B to the market at $1,000, $10 per share at 100 shares. The mark to market allows dealer A to be saved from loss should dealer B fail to deliver the shares. Dealer A has the contract client at $50 per share. Should the dealer B make the delivery, dealer A would have to replace the shares at $60 in the open market, resulting in a 10-point loss of 100 shares. By marking the market, the dealer A receives $1,000. That is the risk and cannot suffer a loss. Conversely, had shares dropped in value $50 to $40 in the open market when issuing trading, dealer B could send a mark to the market at $1,000 to dealer A. The shares trading 10 below the contract price. It's dealer B who is now at risk. The market relieves the problem. Reclamation. In reclamation, the dealer requests another dealer to reclaim the improper delivery of the instant dealer A purchased 100 share United Apple Cider Company stock from dealer B. On settlement, dealer B delivers 100 shares of United Apple Butter Company stock. Dealer A accepts and pays it the next day. Dealer notice the received is wrong. Stock sent to dealer B or the reclamation notice of requesting dealer B picked up the improper delivery, return payment of proper security delivered normally at dealer 15 days of send reclamation notice by the delivered security later proven to stolen counterfeit. The dealer has 30 months to demand reclamation. The over-the-counter market. I'm going to stop the tape there.